Continuing on Article 1, Section 8, Clause 3, to regulate commerce with foreign nations and among the several states and with the Indian tribes. Commerce is the buying and selling and trading of goods. That's the definition of commerce that was in play when this document was written. So, is clean air part of buying, selling, and trading of goods? Is minimum wage part of buying, selling, and trading? I don't think so. Is carbon dioxide in the air, which is something that every living plant and tree needs to survive, is that part of commerce? I don't think so. But they're regulating these things, folks. They don't have the authority for this. Our foreign trade deficit is hundreds of billions of dollars. Congress is totally responsible for this. I remember a number of years ago, our trade deficit was going up $100 billion a year. It got up to $5 or $6 or $7 or $800 billion a year in trade deficits. Who's responsible for that? Right here it tells you. Congress is responsible. They're responsible for commerce with foreign nations. It's pretty clear, isn't it? So we need to start talking to Congress about some of these things. We need to regain our manufacturing ability in this country so we can sell things, have a good balance of trade, not negative like we are. Folks, that's hurting our country, hurting our jobs, hurting our children, our future. Regulating trade among or between the states was supposed to make trade regular. The flow of commerce, according to the Supreme Court, started at the loading docks and ended at the point of sale if it crosses lines. So remember, their regulation was supposed to be acting as an umpire to make certain that one state didn't pass a law or regulation that gave them an advantage, an unfair advantage in this flow of trade. So they had to make trade regular, the flow regular. And it started at the loading dock. It didn't include what happened inside the manufacturer, which would be minimum wage, okay, which they've stretched it into there. It just, the federal government doesn't have any authority over the manufacturing process. It has only the authority to act as an umpire to make sure this flow of trade across state lines is regular and good and profitable. There's been a slow advancement of government usurpation of power. In the beginning, Justice Story said the following in 1833, "In case the words are susceptible of two different senses, the one that should be adopted is the one most closely aligned with the apparent objects and the intent of the Constitution." That's pretty clear, isn't it? You try to find out what the intent was of the Constitution, and that's the interpretation. From there, we've gone to 1870 at Harvard University, where we have the legal positivism that was we talked about this a little earlier. Since there is no God, man evolved, then our law should evolve, and the judges should direct this evolutionary change. That's, again, where we started losing out in this war of worldview. So we're starting to make a transition away now from what the Constitution says. Legal positivism was taught in most of our universities by 1920. Justice Oliver Wendell Holmes Jr. in his book in 1881 flatly denied that there are any higher principles of morality or law that guide judicial decisions. The law, he wrote, is nothing more than whatever a judge says. That's nowhere close to what the original intent of our founders were, folks. By 1937, after President Roosevelt threatened to pack the Supreme Court with his appointees, the court finally ruled the cardinal principles of statutory construction is to save and not destroy. We have repeatedly held that as between two possible interpretations of a statute, by one which it would be unconstitutional and the other valid, our plain duty is to adopt that which will save the act. So to heck with whether it's unconstitutional or not, let's save the act. When Social Security first came out, it was unconstitutional. And it was after that Roosevelt said he was going to pack the court that they got the message. He wasn't able to do that because Congress didn't even allow that. But they got the message, and there's an old saying, a switch in time saved 9. And so now they're ruling not according to the Constitution, they're ruling according to what the president wants. Again, going from God's law back to man's law. This was a huge change. By 1958, in Trope v. Dulles, when they ruled the death penalty be unconstitutional, the court said, in an enlightened democracy, here's that word democracy again, such as ours, the amendment must draw its meaning from the evolving standards of decency that mark the progress of a maturing society. Whose idea was this? It wasn't the people. It was the court's idea. The citizens of the Congress were no longer the sovereigns to determine public policy. It was now the courts that sometimes even referred to foreign law for their decisions. Folks were losing control of our country, and a lot of that's happening through the courts. There are some fixes to that. Continuing Article 1, Section 8. The Clause 5, to coin money, regulate the value thereof and a foreign coin, and fix the standard of weights and measures. Our Constitution has no provision to allow any branch to give away any power, any jurisdiction or authority to another branch or private entity. But the Federal Reserve is a private bank that determines when to print money, which creates a debt for a country and affects its value, and spends money in a lot of areas that are not controlled by Congress. Now, how does Congress have the authority to give the ability to regulate the value of our money, which is they're responsible for, any more than they have the authority to give away the right to declare war? It's solely a responsibility of Congress. You can't shift these things around. If you do, our system breaks down. But that's what we're allowing to happen. Continuing Article 1, Section 8, Clause 11. To declare war, grant letters of marque and reprisal, and to make rules concerning captures on land and water. The separation of powers here is that Congress must declare war and authorize it unless we're under imminent danger of attack and the President, as a Commander-in-Chief, conducts a war. But what happened in Libya? He just started a war all by himself, didn't even mention anything to Congress. And where did he find his authority? In the United Nations or the NATO. He didn't swear an oath to them. He swore an oath to our Constitution, to us, the people. Yeah, where was Congress when this happened? Why didn't they put a halt to this? That's absolutely unconstitutional. Congress makes rules for capture on land and sea. When Congress builds Guantanamo Bay to hold terrorists and try them in military courts, where does Attorney General Holder and Obama find the authority to change the rules? And they change the rules, say, well, we're not going to take the terrorists to Guantanamo. We're going to take them up to New York and try them in civilian courts. Now, I think the rules were set by Congress to take them to Guantanamo Bay and try them down there in the facilities built for the military tribunals. Where do they get that authority? Where is Congress? Where are we the people? We're tolerating these things, folks, out of ignorance. We've got to learn the truth and stand up and fight. Okay, that's what this is about today, to learn, to give you the tools to be able to hold your officials accountable. Continuing Article 1, Section 8, Clause 18, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. This is known as the Elastic Clause because Congress routinely passes laws they claim are necessary and proper, ignoring the fact that the law must be under the foregoing powers. They kind of forget about that part of the clause, or one of the other powers vested by the Constitution. This is one of the biggest problems where this is one of the major violations, this clause right here. They think, well, just because Congress makes it, it's supreme, it's superior over everybody else's. No, it's not, unless it's done under one of the enumerated powers. The necessary and proper clause is the one that's violated here, okay? Things aren't necessary and proper to do unless it's necessary and proper for holding up an enumerated power. Article 1, Section 9, Clause 2. Section 9 covers the things that the federal government cannot do. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or evasion the public safety may require it. Privileges are set aside for citizens. We'll talk about this a little bit more when we get to 14th Amendment. It makes it very clear. According to SCOTUS, the requirement to read your Miranda rights upon arrest is a privilege. Why in the world do we give Islamic terrorists privileges that are set aside for citizens? It's beyond my understanding and comprehension. Where is Congress? Where are we the people? Congress, as much as we are tolerating these out of here, they don't know any more about the Constitution than the average citizen in Marietta, Georgia here. That's where they come from. So we've got to learn the truth about these things, folks, if we're going to save these founding documents. They're so precious to our future and our liberties and our posterity. Article 1, Section 9, Clause 7. No money shall be drawn from the Treasury but in consequence of appropriations made by law. If the president mandates anything that costs money without underlying congressional appropriations, he just violated the Constitution, didn't he? When Obama attacked Libya, it required spending that wasn't legislated for, didn't it? When Clinton required, on the last day or last 2 or 3 days of his administration, he required all federal forms to be printed in over 200 different languages. This required spending that was not appropriated for, didn't it? They do this on a routine basis. Probably 100 presidential orders a day are not unusual, most of which are unconstitutional. And nobody has a clue what's going on with that. He's acting like he's a king, not just Obama, but all the presidents do this. It's time for us to rise up and put a stop to this, folks. Article 1, Section 10, Clause 4. No state shall, without the consent of Congress, engage in war unless actually invaded or such imminent danger as will not admit to delay. Arizona and other border states have been invaded by illegals, drug lords, human traffickers, and so forth. Shouldn't they be able to call out the National Guard to protect themselves? So Section 10 is a prohibition against this unless they're actually being invaded. Well, they're being invaded. I think they have a right to protect themselves under the Constitution.